So this is almost our last Supreme Court case. We'll have one more after spring break, which will deal with civil rights, of course, and that includes that's Brown versus Board of Education. So we'll save one of the best for last. This one is probably the most controversial for sure. Roe versus Wade, 1973. I'm sure a lot of you are fairly familiar with this because it does have to do with abortion. So let's go through this one. We'll go through it pretty quick. All right, so the issue is right to an abortion, and know that by 1973, most states still had laws against abortion, and I may say it wrong, but I think it's around 30 some odd states had laws restricting abortion. Probably more than that, more like around 40 had laws restricting abortion. So that's the issue. The amendment in clause. Now, here's the interesting thing: there's not a direct amendment or clause because the issue of abortion isn't addressed in the Constitution. So what we're going to say is that there's a constitutional principle, and it's called right to privacy. So this is the constitutional principle that's developed, and it's through the due process clause of the 14th Amendment. So through due process, according to Roe versus Wade, you have a right to privacy. Therefore, the right to privacy applies to a woman's decision to have abortion. That's how the decision was made. All right. So if you need to pause, go ahead. All right. Now, a little background. So the precedent for this case was a case called Griswold versus Connecticut. Very famous case, landmark case, 1965. And in this case, there was a law in Connecticut that outlawed contraceptives, that didn't allow adults to buy contraceptives. And so somebody sued, and Planned Parenthood actually sued, and ended up that the Supreme Court ruled that contraceptives can't be banned due to a right to privacy found within the Fourth Amendment and other amendments and things like that. Ninth Amendment, of course. And so they call it the right to privacy. So that's where this term comes from. That's where this constitutional concept comes from. And that's going to be used in 1973 in Roe versus Wade. So fast forward, 1972-ish, a woman whose name was withheld, she had a fictional name called Jane Roe, hence Roe versus Wade, it can't get an abortion due to Texas law. So she sues Texas. Roe sues, saying it violates her right to privacy, and her lawyers said that the right to privacy is protected by the First, Fourth, Fifth, Ninth, and 14th Amendments. All of those amendments, they say, apply to the idea of a right to privacy. So there's this phrase doesn't exist in the Constitution, right to privacy, but like it's kind of inherent, if you will. It's assumed through these different amendments. Key question: does the Constitution recognize a woman's right to terminate her pregnancy by abortion? Does the Constitution recognize a woman's right to terminate her pregnancy by abortion? That's the big question here. Pause if you need to. All right, and the vote was 7-2 for Jane Roe. So she wins, and this hugely consequential decision becomes the law of the land, essentially. And it really has far-reaching consequences because it started the pro-life movement. You know, the anti-abortion movement didn't even exist really prior to 1973, and then it becomes like this huge thing after. The ruling was really two parts. One is that through the due process clause of the 14th Amendment, there is an inherent right to privacy. And I put that in quotes because that's from the decision. So through due process clause of the 14th Amendment, there is an inherent right to privacy. So they're kind of like justifying, if you will, this idea of a right to privacy through the 14th Amendment. And then this protects a woman's right to an abortion. So a woman's right to an abortion is protected as a result of what the Supreme Court says is this inherent right to privacy. And then the dissent is a classic restraintist kind of viewpoint of this, and basically the the dissent was the drafters of the 14th Amendment had no intention to extend the right to an abortion. The 14th Amendment had to do with civil rights; it had to do with African Americans. So therefore, the states have a right to legislate on this issue. So just as just the idea that like plainly the 14th Amendment, if you look at like why the people who wrote it, they had no intention that abortion was going to be legalized as a result of this. So therefore, the dissent would argue that if you want to change the law of abortion, then go change the law of abortion, but you can't mandate it for the rest of the country because the 14th Amendment just doesn't apply in this case. That would be their argument. So classic restraint versus activist decision here. The Roe v. Wade is kind of seen as the classic activist decision using modern kind of beliefs and changes in society, and then kind of almost looking into the Constitution to find a way to justify it. I might add too, just FYI, if Roe versus Wade were ever overturned, it would just return back to states, and you would end up having 50 different states having probably 50 different laws about abortion. So that's where we stand. You need to study this one. This is probably an easy one to study, especially if you have any familiarity at all with it. And then go ahead and do your practices. Thank you.